to Michelle. Okay, Michelle, to you, our president.
Okay, well, thank you very much, Tony and Janet, for organizing this, along with our partner in Luxembourg, AmCham. And in this project here, or this presentation on the Luxembourg US patents, opportunities, guidelines, and for business owners, we're also partnering with Wiedermann Malek, who is a member of the Luxembourg Chamber. And also, I'd like to introduce our Consul General, Luc Decker, who just arrived in New York a few years ago. So welcome, Luc, and looking forward to working with you over the next few years. Our presentations today are with Dan Piron with Wiedermann Malek also, and presenting also is Valerie Mallet with Patent 42. Just a few housekeeping notes. As Tony mentioned, we are going to be recording today's presentation. So also please mute your phones. And then also just a note that we'll be sharing this presentation with social medias. So onwards and forwards. Luc, welcome. I think you're going to be next making your presentation. And again, welcome to New York. On to you, Luc.
Thank you. Thank you very much, Michelle. Thank you, Tony. Thank you, Janet. Thank you also to Daniel and Paul, even though Paul has difficulties joining us today in Luxembourg. It is great to see the LACC and AmCham Luxembourg working so closely together. It's a great pleasure for me to join an event organized by our bilateral chambers of commerce for the first time, and it's certainly not the last time. I love to be in New York and look forward to working closely with all of you. As some of you may know, I've been serving in the same role of Executive Director of the Trade and Investment Office and Consul General in Shanghai before. IP protection was a common point of interest to companies there. A friend and chairman of the Benelux Chamber of Commerce in China used to say, these Chinese are incredible. They have invented a vacuum cleaner sucking all common sense out of business people when they cross the border into China. These people and companies arrive in China and they do not register their IP. Obviously, when then a Chinese company registers their trademark or their patent, they complain that they are not protected. Of course, if you don't register your IP, you cannot be protected. And also in China, if your IP is registered, it can be protected. And I've seen cases where even a foreign SME would win a case against a large state-owned enterprise in China. So, I mean, obviously, you're all following this seminar, so this is no news to you, and you know how important intellectual property system is for you, for your company, for fostering innovation and protecting your intangible assets. And I think this is especially true for SMEs doing business internationally, not only for SMEs, not only for those doing business internationally, but especially for those. The importance of intangible assets is constantly increasing as our economies are becoming more and more innovation-driven, with clear political goals to push and encourage the twin transition to a digital and green economy. In Luxembourg, we understand that IP is part of the equation if we want to transform our economies. This is why the program of the government for 2023 to 2028 foresees to keep legislation on IP up to date and also modernize the patent legislation. Luxembourg has also always supported the establishment of a unitary patent system in order to simplify the lives of companies. We will hear more about the unitary patent system today. It has been introduced in June 2023 It is already effective in 18 countries in the European Union, including Luxembourg. And it is so this new system reduces cost and complexity in Europe, and it is a great example of reducing red tape. The establishment of the Unitary Patent Appeals Court in Kirchberg in Luxembourg strengthens the landscape of European courts based in Luxembourg. It confirms that Luxembourg is right at the center of the new patent system. It is also, I mean, this is the Luxembourg way. We believe that only unified rules can make international business truly thrive. And that's what we believe in, and that's what we try to implement. We make that happen. Thank you. Thank you very much.
Michelle, unmute yourself, please.
Success. Sorry. Nonetheless, look, thank you very much for your presentation. Very insightful on how Luxembourg addresses the patents, and always Luxembourg is on the forefront of these matters. So now on to the presentation, and let me welcome Dan Piron and Valerie Mallet. Thank you for your insightful comments on this topic.
So I will share my screen. And okay. Okay, can you see the presentation? So my name is Valérie Mellet. I'm a European patent attorney and also Luxembourgish patent attorney working in Luxembourg in Patent 42. So I will talk about patent, patentability, and patenting in Europe. So patent is one of the IP rights that can be used as a property. The others are trademark and design, and it protects the technical aspect of the innovation. So design will protect the aesthetical aspect, and trademark is more about marketing, how you distinguish your product from the one of your competitor. There is also copyright that is not intellectual, industrial property, but is part of intellectual property that gives the owner the exclusive right to copy, distribute, adapt, display, and perform a creative work. So IP is intangible good. It's part of the company capital and can be sold, bought, rented, passed, and assigned. The patent is protecting invention, but first we may have to explain what is the definition of an invention. An invention is the technical solution to a technical problem. The patent is a title deed. It's not a right to exploit the invention. It's not as such a freedom to operate. It's just a right to prohibit third party from exploiting your invention and innovation. It's granted for a given territory and for a fixed period. For most of the case, the period can be up to 20 years. We have exception for pharmaceutical patents that can be 5 years more. There is duty for the patentee in compensation of this right, and the duty is the disclosure of the invention to the public. The disclosure of the invention is the origin of the patent system, and it must be sufficient, meaning clear, complete enough for the person skilled in the art to carry out the invention. And the patentee will have also to pay some administrative fee for filing, for searching, for the examination, and for the grant of the patent, and also to maintain in life the patent during all this life. So when you have an invention, you want to check if it is patentable. You have 3 criteria. Precondition, it must be new, it must show an inventive step, it means that it should not be obvious, and it must have an industrial character. There is some subject matters that are not patentable as such, the computers, what is contrary to good morals, and the idea in general, the aesthetic creation, because it's they are being protected by the design. And there is also other things just like the surgical methods that cannot be protected because for the good of all, they may be available to everybody. When you want to patent, you also want to start an exploitation. You may need to know if you have the freedom to operate, and you may read some patent documents. And also, when you want to file and obtain a patent, you will have to draft the patent. But what I want to tell you, it's when you have a patent document in your hands, the first thing you must check is that patent document is an application or if it is a granted patent. Because the protection that will be given by the patent will be defined in the granted claims. And the granted claims may differ from the claim that will be filed by the applicant. The applicant has a very big idea in general of the invention, and the claims of the patent application express the wish of the applicants. The claims of the granted patent reflect what the patent office believes that the applicant is entitled to after having performing this examination to check if the patent is the invention defined in the claim is novel and inventive. So how to obtain a patent? If you are in presence of an invention, meaning you have found a technical solution to a technical problem and you want to protect it, you will start by drafting and filing the patent application, filing to a patent office that will check the formalities and will establish a search report on patentability. So find prior art documents. Then the application will be published and the applicant will reply to the search report to get the patent grant or will not if the country is a registration country wherein there is no examination. What is important is that the patent is published 18 months after the filing or the priority date. Daniel will explain you what is priority and why it is published after 18 months only, because we have a very important deadline at 12 months, and Daniel will let you know what that deadline is. The alternative of filing a patent is keeping the secret for your invention, but you will take the risk that the patent is taken by somebody else, or that people anyway knows your secret by retroengineering. So it's not maybe, it can work sometimes, but sometimes it's always better to have a patent. So now look what can be the patent strategy in Europe. So imagine you have now drafted your patent application and you would like for your business to have a patent coverage in 5 countries. And I take, for example, Luxembourg, Belgium, Netherlands, France, and Germany. You have 3 different ways to obtain a patent. You can go through national patent, you can go to the European patent system, and you can also go to the European patent system, but with unitary effect, what Luc was talking about just a few minutes ago. So if I decide to go to the national patent, then it is possible to file the application in each country in Europe. So in the 5 countries you selected, you can file the application. And depending on the country, you will have to go through substantive examination or not.
Sure.
So if you want a patent coverage,
The list that you saw is the list of
yes, sorry. If you want a patent coverage in Luxembourg, Belgium, Netherlands, France, and Germany, you will have to file 5 patent applications to go through 5 examination proceeding, including 2 with a substantive examination, and it will result in 5 patent granted. So you have 5 times the annuity renewal fee to pay. And as Luc said just before, it's maybe a little complex. So you can go through the European patent. But first, when we are talking for Europe, about Europe, the first question to ask is, what does Europe mean? This is a Euler diagram, and we can see that different definition of Europe exist depending if you are considering the European Union, the Schengen area, the European Economic Area, and so on. And just to let you know, for trademark and design, the European trademark or the European design covers all countries of the European Union, and that's it. When with the Brexit, the UK go out from the European trademark, and if a country go to European Union, the trademark automatically cover European trademark automatically cover this new country. But with patent, of course, because patent is more about science and technical things. We have our own definition of Europe, and we have the European patent that will cover 89 countries, 500 million of inhabitants, and so have some extension test state, validation state. You can validate the European patent in Cambodia, for example. The European patent is a granting system. You have a substantive examination, and after grant, you have the possibility of opposition by third party. Once a European patent is granted, it is converted in a bundle of national patents. So with your patent coverage in 5 countries, you will have a single application to file. You will get a single granted patent after a single proceeding. Examination proceeding, but it will result in 5 patents validated in each of the countries you have selected. We call this the validation system. Then to have the thing even more simple, to have this, to have less and less complexity, since last year, we have now the European patent with unitary effect. So the unitary patent is a European patent wherein a unitary effect is requested, and it covers 18 European states, including Luxembourg, including, in fact, the 5 countries I've given in the example. So if you decide to go through unitary patent, you will have a single patent application to file. It will be granted after 1 examination proceeding, and it will result in a single patent covering 18 states. And it's quite something that is quite cheap, I would say, because for the first decade, the renewal fee for the 18 states is only 5,000 euros. But as you remember, the coverage of the possible coverage of the European patent before, and you compare it to the European patent with unitary effect, you can see that not all the countries goes for unitary effect. Some will never be inside. For example, Great Britain, because the unitary patent is linked to the European Union. Some may join the unitary patent system later on, just like Spain, for example, or let's say other countries. We have Poland, for example, also. And just if you select the unitary effect to have a patent with unitary effect, you do not prevent it. This do not prevent you to have IP patent protection in the other European countries that are not participating in the unitary patent. So if you want to add, for example, Spain, it is possible to combine the unitary patent with the normal EP validation. And to cover these 6 countries, you will have to file a single patent application, but it will result in 2 patents. The unitary patent, that is a single patent covering the 18 states with your 5 first states you choose, and the Spain branch of the granted patent. So that's all for me. I thank you for listening, and maybe later on, if you have any question, I would be pleased to answer.
Thank you very much, Valerie, for this insightful presentation. And on to Dan Pierron.
Thank you very much, Michelle, and also for the correct French pronunciation of my last name, which I unfortunately do not use.
Anytime.
So, hello, my name is Dan Perrin, is how I say it. I am an intellectual property attorney in Melbourne, Florida. Although, thanks to my genealogy, I'm also a citizen of Luxembourg. Yeah, it's my privilege today to share with you this presentation that will talk a little bit more about the international aspects of patent application and prosecution, and then going from international to the national stage. So to start off, there are 2 systems primarily, or there are 2 patent systems for utility patents. To pursue patent protection internationally after you have filed your first application in whatever country you may be, any of the ones that Valerie mentioned, or if you are US-based, you would likely have filed in the United States first. The first system we'll be talking about today is the Patent Cooperation Treaty, or PCT system for short. And the PCT application is best thought of as an intermediate international application. And I say intermediate because it comes after your first national stage application, but before a later national application into whatever jurisdictions you want patent protection. It takes, it's a step in between those 2 phases. And what it consists of is, well, the PCT application facilitates filing applications into any of the 157 signatory states. And the way it facilitates this is by providing search at an international stage before committing all of the resources that you would need to pursue international protection in each jurisdiction. And in the PCT application, there are 2 stages, international stage and then the national stage. So the international stage comes first, so we will discuss it first. And like Valerie was mentioning earlier, the 12-month date is a very important one. A PCT application must be filed within 12 months of your priority application. And your priority application is whatever patent application you filed first on your invention, wherever it may be. The first filed application has, the day you file it, within 12 months of that, that's when you need to file your PCT application. If you don't, then you have lost your ability to pursue patent protection on that invention. This isn't like trademark or copyright, where there isn't really a hard and fast deadline by which you have to pursue protection. In the patent world, this 12-month deadline is critical. If you miss it, you have missed your opportunity for protection outside of the country where you filed your first application. So as a result, as a practicing attorney, we send many letters providing advance notice of this deadline because it is that critical. When you file your PCT application, you select a national patent office as a search agent. As Valerie mentioned, there is substantive examination performed on patent applications in most jurisdictions. And this is one of the benefits of the PCT application is before filing in all of those individual jurisdictions, you select a national patent office as a search agent, and they are going to perform a search of international prior art. This is certainly in the case in the United States. When you file an application in the United States, they tend to only look at previously filed patents and applications in the United States. They don't spend as much time looking at applications filed outside the United States, including in Europe and most other major patent office. But with the PCT, when a PCT search is performed, they have a much broader view of considering prior art from many different jurisdictions, including the United States and the European patent system. Now, when they conduct this search, they also the patent office that you have selected also provides a non-binding opinion on patentability. And it's non-binding because this is only an intermediate stage. It's not, this application itself will not result in a patent. And as such, the opinion that is given after the examiner conducts their search is not binding on any subsequent application that you may submit a patent application on in whatever foreign jurisdiction. It is persuasive, and it is usually identifying some of the most relevant prior art. So it needs to be taken seriously, and you need to start forming your arguments responsive to an opinion that comes from the PCT search. But it is not going to, most importantly, it's not going to limit the subsequent patent offices from conducting their own searches and rendering their own opinions on patentability. The requirements for patentability, Valerie had touched on earlier, so I won't spend much time on it, but it's those three requirements. And then once you've gone through the international stage of a PCT application, you enter the national stage. So the national stage has a deadline of between 30 and 31 months from your priority date. So two important deadlines. After you file your priority application, 12 months to file your PCT application, and then depending on the country, either 30 or 31 months from that priority date to file your national stage application. In the United States, it's 30 months. In the European Patent Organization, it is 31 months. And there are some instances where you can kind of push that deadline back a little bit up to 32 months, just to meet some local filing requirements. Most notably, getting translations in China can be time consuming, but you can file your English application at 30 months and submit your translation 2 months later. As I mentioned, the deadline depends on the country. And it's at this stage, at the national stage, that binding substantive examination occurs. And so let's say you file your first application in the United States, file your PCT application, and then before that 30 or 31-month deadline, file in Europe, Canada, Australia, Israel. Those are some of the major markets, Japan, South Korea, China. In each of those individual countries or organizations, they are going to conduct their own search and render their own opinion on patentability. This is, as I mentioned earlier, the international search and opinion is influential, but non-binding. They're all going to render their own requirements, and that's because in some instances, rather significant differences exist between the requirements for patentability in each of those individual offices. Many times I am able to obtain a patent using claim language in one jurisdiction that does not work in another jurisdiction. I file and work with actually Valerie to a significant extent on applications I file in the United States, and the same language does not work in Europe. And so, there is definitely going to be differences in whatever patents might be issued from a single application. As I mentioned, to that point, each country or region, it gets prosecuted independently of each other. So the benefit, pros and cons of the PCT application. The pros: it's a simplified, streamlined foreign filing. You get a search before committing all the resources to filing in each individual country. And if you're going to be filing in 5 different countries, it would be nice to know the relative chance of you obtaining a patent on a given invention. If it just so happens that unfortunately there's a piece of prior art out there that is really basically impossible for your application to overcome, and it's time to cut your losses, not spend more money pursuing something that has little to no chance of being successful. Another benefit is that it delays costs for filing in multiple countries. As I mentioned before, that you have the 30 to 31 month deadline for filing in all foreign jurisdictions. I'll be discussing the second system that does not have a similar delay. And by and large, because you have additional searching going on, it improves the quality of resulting patents. Now, the cons are that it increases the total cost of filing, because that international stage, it just pushes the total cost up a little bit. Not a whole lot in the grand scheme of filing in multiple countries, but it does add a little cost. That additional cost usually requires to be filing in 3 or more jurisdictions to justify that additional cost. That's my usual way to gauge whether it's worth it or not. And it's of limited strategic value if you're committed to filing national stage applications. If the international search opinion is not going to change your decision to file, then maybe just go ahead and filing. And lastly, taking full advantage of timing reduces the period of enforcement of a reducing patents, because you're going all the way back to the priority date. Valerie mentioned that most patents are good for 20 years. Well, that's 20 years measured from your priority date. And so by taking additional time to get to the national phase and your resulting patent, that ends up shortening the length, the period of enforcement of the patent on the back end. So now we will talk about the other system, the Paris Convention, and some of the finest AI-generated art to illustrate that point. So the Paris Convention is different from the PCT in that you have to file directly into the foreign country. There's no intermediate application. Now, that same 12-month deadline is present for the Paris Convention. And so ultimately you have a strategic decision to make at that 12-month mark, or well in advance of it, so you're not doing this on the day of. You're either going to go the PCT route and have that international step and delay filing in all the foreign jurisdictions until the 30-month deadline, or you can go the Paris Convention route and at that 12-month deadline, file in all foreign jurisdictions that you want protection. Now I'll talk a little bit about the national phase application, and this will be primarily for US applications. We've discussed some of the requirements for patentability, and a lot of this will be very similar for national phase applications into the EPO, but not identical. So right off the bat, it's 30 months for the United States, 31 months for the EPO. In the United States, if you miss this deadline, you do have the ability to file a petition to revive the application. I'm not aware that a similar procedure exists in the EPO, but it does exist in the United States, and with all things, comes with a fee, an additional fee. When you file the national phase, the claims, the legally enforceable part of an application can be amended. Given the brief time we have today, I will just mention that, and maybe we can plan a subsequent discussion about all the important considerations of patents in the future. Usually this is done to conform to US conventions. There's just differences in practice that I had mentioned before between Europe and the United States, and then between any 2 jurisdictions, there are differences. And so a small amount of work has to be done in order to make the application appropriate for whatever jurisdiction they are entering. And then the written description or like the application itself can be supplemented, but that's kind of an unusual situation, and I won't spend too much time on that. In the United States, the applications get evaluated for patentability. Each of these three requirements are roughly analogous to the requirements in the European Patent Organization. So patentable subject matter is similar to industrial applicability. Novelty is similar to novelty. And then non-obviousness in the United States is similar to the inventive step in Europe. And then lastly, Valerie had suggested I mention this, what's called a provisional application in the United States. And as it's not, there isn't a similar option in Europe. So in what we've been discussing for the United States is what we call a non-provisional application, in that it is a patent application that gets substantively examined by the patent office and a patent can issue from it. Another option, if you are earlier on in the development of your invention, or you just don't have quite the legal budget for the preparation of a full non-provisional application, is you can file what's called a provisional application. And I view this as sort of a stopgap application where you want to get something on file with the patent office, and you have kind of the core of your invention detailed, but not all of the permutations, all of the options. Not everything is figured out yet. And so what you can do is you can file this provisional application at a significantly lower cost, and you establish your priority date with a patent office. And so, as we were talking about before, you have that 12 months to file your international applications. Well, you can establish your priority date earlier on in the process, or earlier on than you would otherwise be able to at an earlier date by filing this provisional application. A big difference between provisional and non-provisional is a provisional application does not get substantively evaluated by the patent office and itself cannot result in a patent. Instead, a non-provisional application must be filed within, here's another important deadline, that 12-month date. It is the same deadline as for seeking international protection. So a lot of important things happen 1 year after filing your application. So it's an important deadline to keep in mind and talk with your patent attorney about well in advance, so you can make sure that you have a good strategy and have allocated a sufficient budget to match your IP strategy. And that brings me to the end. So thank you very much for your time. I really appreciate the opportunity to talk about these issues with you. Please feel free to reach out to me if you have any questions on the US side, or as Valerie mentioned earlier, please reach out to her on the Europe side. And at this point, I think we welcome any questions that you may have.
Thank you very much, Dan and Valerie. So, yes, Daniel and Valerie, any questions from our audience?
If I can add something to Daniel's presentation, yes, there is something similar that exists in Europe when you miss the deadline for entering the PCT. The Euro PCT application, you can request for the processing for 2 months. You have to pay a very big fee, but okay. And as Daniel said, I asked him about the provisional application because this is something that does not exist in Europe, not yet, but it does not exist.
Thank you.
Daniel,
Well,
what recommendation would you make to someone that has an invention coming up that is working on? What would you recommend for them to do, because they're working on it, they think it's a good invention, and and they just want to wait until the end of that it's perfect or whatever. What would you recommend for them to do? What do you think?
The first thing is to not talk about it publicly, because there are very significant consequences to talking about inventions publicly. In the United States, if you make what's called a public disclosure, where you talk about your invention in sufficient detail that someone could take that and make your invention, that triggers a 1-year grace period, again, 12 months, within which you have to file some type of patent application. If, 12 months after you make that public disclosure, you haven't filed anything, then you have forfeited your ability to obtain patent protection on your invention. So that is the first thing. Second, kind of correlated to that, is if you do need to discuss something with it, with another individual, and if that person isn't an inventor of the invention, isn't really working very closely with you, but you need to disclose sufficient details to them, try to have an agreement in place that binds them to confidentiality. Now, if this is happening in a corporate context, then your employment agreement with that individual should include a provision that dictates not only that they have to maintain the secrecy of the disclosures, but also obligates them to assign their ownership of any patent application to the company. Because that's an interesting thing about patents is the inventors each have an individual ownership right in the patent and have no duty to account to the co-inventors. So if you file a patent application, you get a patent, and 2 people are listed in inventors, person A can go and license it, sell their interest, do whatever they want, and they don't know anything to person B. And so there's obviously a risk for conflict of interest there. And that's why frequently you have a corporate or a business ownership of a patent application to make sure you harmonize those interests and you don't have 2 parties working against each other. So those are maybe 2 of the things that I would think about. Valerie, is there anything that comes to mind for you?
I would say also that it is nice to have the help of a patent attorney, because because drafting is not that easy, and if you want to determine the scope of the protection, you need also the help of a specialist.
Yeah, when I talk with clients, I talk about IP on a spectrum in terms of difficulty. On the easiest end is copyright, because that's usually a pretty simple form to file. In the middle is trademarks, where if you've been through the process before, you can probably do an okay job preparing the application and filing it. And you can still trip yourself up, but if you've been through it enough, then you probably are aware of some of those hurdles. Don't try to do a patent by yourself. It is too complicated. There are too many ways to mess it up. And you will ultimately be doing yourself. It sounds terribly self-serving because I'm just saying, well, you have to use me. But really, people who do not have experience drafting patent applications have little to no chance of producing a patent that has anything of value. Just because there are so many things they don't understand, so many rules they don't know about. If you didn't know about the 12-month rule, then you could very well have forfeited your patent rights abroad, and that may have been important to you, and you just wouldn't have known. And that's not even to get into what it takes to actually draft a patent application, all the rules you have to be aware of. So yeah, Valerie's point is exactly correct.
And the other question was, not a question, but a comment. You said that the agreement needs to be in place. So say that it's an inventor, someone like me that just came up with an idea and I'm working with somebody. It should be then a lawyer has to do that agreement, or can it just be a written agreement between 2 people? You see what I'm saying? And could it just be in writing saying that, it's my invention, not yours, and you cannot disclose any information. So does that have to be written by a lawyer, that kind of agreement?
Certainly needs to be written and signed by both parties. Whether you could probably find something online, but you're risking that it's not going to be, you're not going to fully consider everything that you want considered. And there could very well be things that you don't think of that an attorney would know to look out for. So, this kind of thing is frequently an issue just of what your legal budget is. And you're a business owner and you have to make the right business decision. And usually the safer, more prudent route is to use an attorney, because you can have a higher degree of confidence in whatever document they produce compared to something that you grab off the internet. But if that's not feasible for you, much better to have something in place instead of nothing, because if it's just a verbal agreement, then that's equal to nothing.
That's amazing. Okay,
I agree.
yeah, it's scary in a way, okay. All right,
Well, does that mean that all the inventors are lonely people working in their corner all alone, not talking to anyone? Because if they talk about something, the other person can,
steal it.
yeah.
That's why we get to talk with them so much,
I
because they're
have a
so eager to
question.
talk about their invention with someone. They just got to tell us all about it.
Alina has a question.
I do have a question. I understand that my question is, for example, invention was like done, a similar invention was done, but utilization of the invention completely different. Could be, although design changed a little bit too, could be utilization of invention patent with some changes in invention. Because, like, for example, completely different, like I don't know, people used to put hats on head and you just, you know, using it to step on. What I mean, completely different utilization of the subject. You improve the subject, you change it, change the design, and utilize completely different way. Could be it's part of the patent.
I think there is a difference between patentability, as I said, and freedom to operate. You may have the possibility to patent something that is, let's say, an improvement of an invention that is already patented, but this does not mean that you will have the right to to exploit this new invention, because you patent will be dependent from an earlier one. This is why I said this is not a freedom to operate. A patent is a right to prohibit, but it's not a right to do.
Okay.
And in the United States, if there are not truly substantial differences in the structure of the device that you're using, this could give rise to what we call a field of use rejection, where it's just like you're saying, you're taking the same invention, but just using it in this different context. And if there is not substantial changes, and if the benefit of using that device in this new context would be somewhat predictable, then that is unlikely to be patentable.
Okay.
If, however, it has these unpredicted, if it's way more successful than you would expect, and you can demonstrate that, having sufficient evidence to show that, then you have a decent chance of it being patentable.
Can you repeat one more time what you just said? If it is, yep.
Yeah, if you have evidence that shows you take this known invention, use it in a new context, and it performs much better than you would predict, then it's possible that it could be patentable.
All right. Thank you. You answered my question. Thank you.
But then it will be the use that will be patented.
Right. Yeah.
Okay, but but you answered my question. I understood the direction that I understood.
Yeah.
Okay. Well, thank you very much, everyone. I'm not sure if Paul
Or Daniel.
No, Paul unfortunately still didn't manage to get online, but I will,
Okay.
on behalf of AmCham, thank
Okay.
everyone for having been there for this great presentation, which I also believe for some people could be very challenging depending on the product which they invent, and of course the waiting time associated to it. And it could get frustrating to find out that somebody who invented a similar product with the same functionality could actually beat you to the line, and you would lose everything you created. But I guess those are the risks with millions of people and Europe, or where we are here, being a very competitive place, and a lot of people inventing a lot of stuff. And then we also, of course, we also have the US as a big competitor then to Europe. So it doesn't make things easier. So I wish all the inventors out there to be quick and get their pattern organized before somebody else steals their ideas.
That's true.
All right.
Oh.
I think that Tony and Janet concludes our presentation. Of course, I want to thank everyone for joining. And of course, thank our presenter, Daniel, Valerie, and Luc. Great collaboration with AmCham. We had so many during COVID. We have slacked off a little bit now that we have managed to recover from COVID, but it's always good to have new topics to discuss with those AmCham partners. Thank you very much, everyone. And
Thank you.
Thank you,
all.
everyone.
Thank you,
Bye.
Daniel.
you.
Thank you,
Thank
Maggie.
you.
It was
Bye-bye.
wonderful.
Thank you so
We
much.
appreciate it.